A lot of potential clients in Florida, when they're first speaking with an attorney, one of the very first questions they'll have is, what can I expect? What's going to happen to me? What are the punishments? What are the penalties? If I'm convicted, what am I going to go to jail? Am I going to get my license suspended? What am I going to be doing? Well, it's a complicated answer because a lot of the potential punishments for a DUI depend on several things. Florida looks at DUIs in a number of ways. First thing that they're going to look at is, what number DUI is this for you? Is this your first offense, second offense, third offense, etc.? Second thing they're going to look at is it a breath alcohol? Is there a urine specimen with drugs in it? Is there a blood sample? And if so, what is in it? So it's going to be the indicators of impairment, measured breath and blood alcohol levels, or presence of narcotics in your system. The next thing they're going to look at is, if it's a blood alcohol or breath alcohol level, is it above or below 0.15? If it's above 0.15 in Florida, it does trigger additional sanctions on top of a below 0.15 DUI case. Beyond that, they're going to look at other facts of your case. Was there any property damage? Was anybody injured? Was anybody severely injured? Was anybody killed? All of these things make a huge difference in the outcome of a case. Most people are first offenders, right? But there's several other instances where people come back in a second, third, fourth. When that is the case, it's going to be, when was your last case? So in Florida, on a second offense, it will be split whether it was inside or outside of 5 years. On a third DUI in Florida, it will be whether it was inside or outside of 10 years from your second DUI. And if it is inside of those windows, then it will bump the offense level up. Especially in the third, inside of 10 years, it'll actually make the charge a felony rather than a misdemeanor DUI. In Florida, a fourth or subsequent DUI is always a felony. The outcome in the case, there are minimum mandatory sanctions when it comes to DUIs, and I usually just try and define what will happen on a first offense, because that will be most people. So if convicted of a DUI, first offense in Florida, there are minimum mandatory sanctions, which means the state attorney and the judge have no discretion in waiving these sanctions. They are by statute. The legislature has dictated that if convicted of the DUI, a person shall complete these sanctions. So those sanctions on a first offense are a period of probation. Initially, it will start at 12 months, and a person may be able to terminate that probation early, but you would have 12 months to complete, at a minimum, a DUI school, 50 community service hours, a 6-month driver's license suspension, and a 10-day vehicle impoundment. It can go up from there. That is merely the floor. Oftentimes, judge will ask for a victim impact panel, which is a 2 to 3 hour seminar that you can go to in person or online, where you don't really interact, but you will listen to people who will tell their story of how a DUI changed their life, victims of cases, etc. Courts can suspend your license for more than that a lot of time. Courts can impound the vehicle for more amount of time. If your breath alcohol level is above a 0.15, a court will mandatorily add an ignition interlock device to your vehicle, which means you will have to install one of the systems where you're going to have to blow into it to start the vehicle, and that will all be reported to the court. There are court costs, fines, cost of prosecution that can go with it, and depending on the severity or depending on the unique circumstances of your case, a state attorney's office can ask for additional sanction. When it comes to a second, third, fourth, or subsequent offense, it can get really dangerous for a person considering the driver's license suspension. It can also come into play if a person's prior DUI included a refusal to provide a blood, breath, or urine sample, and if the new DUI also includes a refusal for a blood, breath, or urine sample. Do know, if you ever refuse to provide a blood, breath, or urine sample, if lawfully requested on a DUI, it will trigger a license suspension. If you ever do it a second or subsequent time, it's actually its own misdemeanor charge of refusing to provide a blood, breath, or urine sample. So again, I'll have a potential client contact me, hey, I just got a DUI, I got one from 2 years ago, but I refused this time. Well, if they hadn't refused the first time, say they provided a breath sample, well, this refusal is a first refusal, there's going to be an administrative driver's license suspension triggered. If they'd refused on the prior DUI and now refused again, that's its own criminal charge. So what can often happen is maybe you can get around the DUI, maybe the state has a hard time proving the elements of impairment because of the refusal, but they're going to have you stone cold locked on. All they have to do is show your driving record, a certified driving record that you refused before and that you were lawfully requested now and you refused again, and likely be convicted on the refusal, and all of those DUI sanctions can be applied just on the refusal. So again, if this is a criminal refusal case, make sure you advise your attorney that there's a prior refusal, because it will greatly affect the punishment phase of your case. Do know that if your DUI case is reduced to some other charge, oftentimes what's called a reckless driving, where alcohol or drugs are a significant factor in the charge, there are no minimum mandatory sanctions. So things are discretionary. You may very well get some of the same, if not the entire same sentence as in a DUI case, but oftentimes things like the driver's license suspension will be waived. It's not required. So if your case is reduced, there is a wide range of discretion. I've had reckless drivings where it's just a fine and nothing more. I've had clients with reckless drivings with a whole host of probationary sanctions, including jail time. If your case is reduced all the way down to a careless driving, which I can say is pretty rare, but if it is, then that's nothing more than a civil infraction. It's just going to be a fine and nothing more. Discuss with an experienced attorney the facts of your case, what you have going on, your entire criminal history, and that will help shape kind of an expectation of what you are looking at. One other thing to note is your entire criminal history will be reviewed by the state attorney's office. So again, I'll have clients, well, I got in trouble, but that was 8 years ago. All right, they're going to factor in that it was 8 years ago and it was a long time ago, but depending on what it was, it's going to come up and may have an impact in sentencing in your case. If you have a whole bunch of small charges, but they are all alcohol related, and now you've got your first DUI offense and it's alcohol related, it's going to show a pattern, and the court and the state attorney's office is going to tailor a resolution for you, likely to include some heavy duty sanctions that might include substance abuse screening, counseling if recommended, etc. So again, no two DUI cases are created equal. Just because somebody you know got a certain sanction doesn't mean that you will either get something better, worse, or the same. Just know that if convicted of a DUI, there are certain minimum mandatory, i.e. a floor, sanctions that you would need to complete.